are in what is known in law as local parentis for the children. They are acting as guardians for the parents and the guardians as well. Should they be allowing a child to do anything they want? That for them is what this judgment tells them.
Exactly. That is the wrong perception that they have, and that must be corrected. Yeah. And they have not even, when you listen to the Nagrat, they've not, at the point that he made that statement, he hasn't read the judgment. So I was a bit laid back as to what informed them. Because they have already premeditated what exactly the issues are, they decided to put in whatever they want to say. But this case has made it clear as to the engagement of rules and regulations and vis-a-vis how the right of children must be placed within the rules.
So what are you thinking about their current circumstance? Like Professor Kwaku Asare says, he would have been happy that there was some compensation for the students. We don't know if Achimota has made any, special plans for them, because they reported to school. Tyrone went yesterday, and he went straight into an exam hall. What do you think should happen in that circumstance?
Well, for him sitting for the exams, it is a decision that we arrived at. I think before he goes to Achimota, we had a meeting with them, together with the parent, and then we asked him that, when going to school, there's going to be an exam, do you want to sit for the exams? And he said, okay, he wants to try it. So it is not an issue that Achimota compelled him to write the exams, but it's a decision that we took, that he should go to that process.
No, he has told the world that he and I think Oheniba have told the world that they were learning using a Wolo TV.
Exactly.
But that's not the same as sitting in the class and being tutored by, being taught by the teachers who have set the exam questions.
Exactly.
Aren't you thinking about something special that Achimota should have decided on its own to do for these boys?
Of course. Achimota would have decided that they want to do something for the children, but because of the nature of the case, they also relegated that responsibility. And even in the judgment, when the interlocutory injunction was filed, it was also denied because in the minds of the ladyship, she wanted to speed up the process. So certain things were denied.
And this has been very fast.
Very, very fast. And I have to even commend her for doing this, because she even made it clear that he has about 6 months to write the judgment. But because she wants the children to be in school, or whether it is the decision go by saying that school rules stands or the religious belief stands, she still wants the student to go to school, so she wants to speed up the process. So for me, the court took the interest of the children at heart. But other institutions like Achimota and Attorney General, in my opinion, did not really consider the right of children when it comes to their best interest. And that, for me, is something that we need to open the discussion up, so that what exactly do we want for our children, so that we clearly define it within our legislation.
Let me get Professor Asare and Oliver to wrap up for us in some 2 minutes each. And let me correctly refer to the person who said we should then allow prostitutes and galamseyers to operate if Rastafarians should be admitted to the school. The comment was by Stephen Bosomche Ayensu, former Methodist Bishop of the Obuasi Diocese. Former Methodist Bishop. My Presbyterian friends are on my neck. All right. Yes, so, Prof, the appeal is going on. We know appeals can take a while. If it took, say, 3 years before a decision was made, then it would have become useless, really. But supposing this appeal too gets a speedy attention, and it is decided quickly and it goes against the students, what do you foresee could happen?
Well, in that case, in that hypothetical, it will go to the Supreme Court. But let me go back and say that I completely share the socio-cultural analysis that Oliver did previously. And I agree with Mr. Pierce's emphasis on child welfare. But I want to spend my 2 minutes on the point raised by Mr. Baku, Dr. Kwaku Baku, Honorary Dr. Kwaku Baku, on the GES, the GES. Let us remember something, that the GES at one point actually directed that the kids should go back to school.
That's right.
And then somehow, Achimota was able to overrule the GES. To me, that's the problem.
That's right.
We cannot have 1,000 headmasters determining religious policy for all our public schools. And that's why we have the GES. The GES, in this case, in my mind, allowed Achimota to walk over them.
I agree.
Now, in where I am, the equivalent of the GES, they make available guidance or regulations, booklets to headmasters on certain religious matters. So we are talking about the Rastafarians, but we also have the issue of, let's say, Ramadan and fasting. We cannot countenance a situation where every headmaster decides whether he's going to allow or not allow fasting. The GES must have guidance on that.
Sure.
Ramadan requires fasting, and if a student wants to do it, schools should allow them to do it. And here's what schools can do to facilitate that process. The second and last point I want to make is that the board of governors of these public schools must understand that they are not running private clubs. They are running public institutions. And so if their values are such that they cannot tolerate religious diversity, then it is not in their power to use public resources to litigate, to negotiate, and to depreciate human rights policy that has been endorsed by the Constitution, the General Education Service, and the Ministry of Education. What they can do is to resign. But I cannot understand how we countenance a situation where some board of governors have decided that, well, they are going to use public resources to litigate positions that their own Ministry of Education and General Education Service have endorsed. So those are the two things that I think we need to address and update our minds to.
Thank you.